Well, Simplex system, like the word says, has simplified the planning process. It has brought some revolutionary rules where we do not actually need an habitation license anymore, which used to be such an important document. But actually, from a buyer's point of view, the existence of the habitation license or not, and do note it's been replaced by a document, but the existence or not of an habitation license doesn't really change our due diligence, because we always requested the plans of the property that were approved by the local municipality. So we still get those plans. A surveyor will still confirm if the house is in compliance with the project there is in the municipality. So from a safety point of view for a buyer, nothing really changed, particularly in this area where we were always very thorough with the planning checks and with the survey reports. So it has changed. We do not need to show an habitation license. We still ask for them for the properties that hold them. And for those that are now being licensed with this new document, we do receive a document confirming the property is suitable for habitation, even if it refers to the responsibility of the technicians that have signed the projects. From the point of view of someone that buys a plot, or indeed buys a house, knocks it down and plans on building, then there's been significant changes. The normal licensing we used to have could take up to 2 years to secure planning and start construction, which was not good. Investors would be sitting on their properties for a very long time before they could start construction. Now with this new system, which is very, very similar to the one we had already before Simplex, we can secure planning within 3 months. It relies pretty much on the responsibility of the professionals that the owner of the property hires to do the architectural drawings, the engineering. So the municipality has waived some of its responsibility to the private sector. So in some properties where we may have doubts about levels of the plot or certain specific questions that the client may have as to how far he can go with planning, I am advising my clients to do a PEEP, which is a file where the municipality actually issues a binding decision. So technicians make the application and the answer we get, if it is positive, it is binding. We now know the boundaries we can maneuver our process for planning on. So all in all, I think it's a good change in legislation. We're all adjusting. There's still quite a bit of rules that need to be added. We know the current government is reviewing it already because it is a complete change on the way we were used to work. Banks have had to adjust when they're financing, but it's good. It's a good change. That's a very interesting question, because actually on inheritance and succession, you have two worlds. You have a tax world and you have a legislation world. Which law will apply to my estate when I die, and which taxes will my estate be charged upon when I die? So on the legislation, we have in force, it's an earlier legislation, but it's in force since 2016, EU legislation that determines that the law that applies to succession is the law of last residency. This does not apply to Irish individuals, British individuals, or countries outside of Europe, okay? Because even before Brexit, the UK did not subscribe to this legislation, nor did Ireland. And the rule there is actually the law of nationality rules succession, okay? For other individuals, it is the law of last residency. A Belgian national, a Dutch national, Spanish national, if they live in Portugal, the law that applies to their estate is the Portuguese law. They can choose the law of nationality. So whilst until this law came into force, I used to say to my clients, you do not need to have a will in Portugal. You may choose to have a will to expedite matters, but there was no need. Now I find that there is a need to have a will, particularly if you are a resident in Portugal, so you can choose a legislation with which you're more familiar with. Probably not the Portuguese law, probably the law of your nationality. So in terms of law that applies to succession, very clear since 2016, EU national that isn't Irish, the law that applies is law of residency. If the person does not reside in Portugal, the law that applies is their law of nationality. In terms of taxation, we do not have inheritance tax in Portugal at this stage with direct beneficiaries. So between spouses and parents and their children, we do not have inheritance tax. We have with third parties, if I leave an asset to a niece, to a nephew, to a friend, we have a stamp duty that is of 10%, but not with direct beneficiaries. So this means that people believe that if they live in Portugal, they will be under the Portuguese non-inheritance tax legislation. It is not necessarily like that. For example, a British individual that has been a resident of this country for quite a few years, if they have not exited domicile in the UK, or even if they have exited domicile in the UK, but they have assets in the UK, they will continue to be taxed in that country. So even though in Portugal there may not be the payment of a tax, there is most likely, or for sure, payment of tax in the UK if the assets are there or if domicile has been kept. So it's a case-by-case analysis. It's very important to understand that it's become more relevant to look at this because of the country of residence and country of nationality, and also very important to plan the tax situation in time.